The honourable member for Timmins James Bay is rising on a point of privilege, I believe.
Thank you, Mr. Speaker, and I don't know if I've had the opportunity to congratulate you on your excellent position as my neighbour and as Speaker of the House. And as we're talking about the relationship between First Nation people, I'm rising on a point of matter of privilege pursuant to Standing Order 48 to state that I believe my parliamentary privilege was violated by the Minister of Justice and his staff. It is my belief that the Minister and his staff misled the House on a fundamental issue, which is the legal costs fighting Indigenous children at the Human Rights Tribunal and in federal court. And I consequently believe that since they provided this misinformation, that he should be held in contempt of our Parliament. We've had a lot of talk this week about the importance of the rule of law, and I find this issue especially pertinent when we're talking about the actions of the Justice Department and the Attorney General, who apparently believe they're above Parliament when it comes to their obligation to respond to order paper questions on fundamental questions of fact, not opinion on facts. So if you'll indulge me, Mr. Speaker, I will present the facts of this case as succinctly as possible. On December 9, 2019, I gave notice pursuant to Standing Order 39 of a written question seeking information regarding the legal fees for the hours and the associated costs the government has incurred due to the legal proceedings related to the Human Rights Tribunal cases against First Nation children between 2007 and 2019. The Department of Justice provided a written response to this question in late January 2020 by stating, and I quote, "Based on the hours recorded, the total amounts of legal costs incurred amounts to approximately $5,261,009.14 as of December 9, 2019. Now, as a standalone figure, the idea that the federal government would have spent $5.2 million fighting against the rights of the most vulnerable children in this country, it alone is shocking. However, it has come to my attention that these numbers are extremely misleading. And this has been the first opportunity I've had to bring this forward, Mr. Speaker, because the evidence contrary to the justice officials came out last week when I was representing Canada in Washington. So this is my first opportunity to address this. Ms. Cindy Blackstock, who's been involved in this case from the beginning, has tabled the amount of from documents she's received through multiple ATIPs from the Justice Department about the costs incurred between 2007 and 2017. And the number Ms. Blackstock has provided through the Justice Department's own documents is at $9.4 million spent fighting Indigenous children in court. APTN has analyzed the numbers, and they've come up with a slightly more conservative figure of $8.3 million as of 2017. But that is still substantially higher than what this minister has stated they've spent up to now. Because this does not include any of the costs incurred after 2017. And I'll remind the Speaker, when this government was found guilty of reckless discrimination against First Nation children in 2016, the Prime Minister of this country made a solemn vow that he would respect the rulings of the Human Rights Tribunal, that he would address this and he would not fight this. And yet there's been 9 non-compliance orders later, as well as a battle in federal court attempting to quash the ruling and deny the rights of the children who are in the broken child welfare system. So it is clear that the numbers that we have up to 2017 from the minister's own office are much higher than 8.3 million and much higher than the false 5.2 million that he provided through the order paper. Now, Mr. Speaker, how is it that the House can make sense of these contradictory numbers? We're not talking about opinions here. The issue goes to the heart of the Prime Minister's promise on reconciliation to create a new relationship, and that new relationship must be based on trust. And it must also be based on the trust of parliamentarians when they used the tools like the order paper question to get factual responses that they can do their jobs. This ongoing legal battle against First Nation children has had a corrosive effect on this Prime Minister's brand, and it would appear to me that it can't be explained away as a matter of opinion, that this would be an attempt to downplay the numbers. Page 111 of Erskine May's Treatise on Law, Privileges, Proceedings and the Usage of Parliament explicitly states that misleading the House can be considered an issue of contempt. quote, the Commons may treat the making of a deliberately misleading statement as a contempt. I will forward that to you, Mr. Speaker. Similarly, page 82 of the House of Commons Procedure and Practices quotes the United Kingdom Joint Committee on Parliamentary Privilege and listing various types of contempt includes deliberately attempting to mislead the House or a committee by way of statement, evidence, or petition. That's page 82. Now, we know that being wrong isn't a matter of privilege, but misleading the House is. That's why various speakers, your predecessors, have used the test laid out in page 85 of the House of Commons Procedure and Practices. Quote, the following elements have to be established when it is alleged that a member is in contempt for deliberately misleading the House. 1, it must be proven that the statement was misleading. 2, it must be established that the member making the statement knew at the time that the statement was incorrect. And 3, that in making the statement, the member intended to mislead the House. Mr. Speaker, I believe these tests can be met in this case. Because if we review the criteria that I've just read, the statement given to me was misleading because there exists in the public domain, in the own documents of the Minister of Justice, conflicting information regarding these documents. The Minister only provided me with the cost of the hours recorded, but not with the associated legal fees. 2, the Minister knew that his statement was misleading since his ministry in which he is charged provided different information to Ms. Cindy Blackstock, yet his signature on the document was tabled in the House. 3, the Minister intended to mislead the House since he intentionally avoided to answer the parts of the question that would provide clarity, a point made clear by the fact that the Minister omitted to mention all additional legal fees and only provided the cost of hours. Mr. Speaker, this isn't about being wrong. This is about the fundamental question of the obligation of the government to speak truthfully in this chamber. I would note that previous speakers have ruled that in the event of contradictory information, the matter can be brought to the House to be dealt with. For example, the Speaker on March 3, 2014 stated, quote, the fact remains that the House continues to be seized of completely contradictory statements. This is a difficult position in which leaves members who must be able to depend on the integrity of the information which they are provided to perform their parliamentary duties. Accordingly, in keeping with the precedent cited earlier in which Speaker Milliken indicated that the matter merited, quote, further consideration by an appropriate committee, if only to clear the air. I believe that same situation exists today, and therefore the remedy should be the same. In conclusion, Mr. Speaker, the fact that the Canadian government spent a cent fighting its own citizens, the most vulnerable of its citizens, in court to deny them their Indigenous rights, their human rights, is callous and shameful. However, that the government misled the House and provided incomplete or inaccurate information regarding the amount of money that they've wasted on such reprehensible actions is unacceptable. I ask this government to answer these fundamental questions. We need to know that what the government is going to respond in an order paper question are true and accurate figures about how much money was spent at the Human Rights Tribunal, and in accordance with page 63 of Erskine May's Treatise on Law, Privileges, Proceedings, and the Usage of Parliament, which state that, quote, it is of paramount importance that ministers give accurate and truthful information to Parliament, correcting any inadvertent error at the earliest opportunity. Secondly, Mr. Speaker, I'm demanding that the Minister of Justice explain to this House and to the Canadian public why the information that was provided in response to the order paper question differs so much from the information that was provided to Ms. Cindy Blackstock through multiple ATIP requests in his own department. The Canadian people have a right to know. And in conclusion, Mr. Speaker, and I'll wrap up here, this matters because what we're dealing with are the lives of children. It mattered to Kanina Sue Turtle, to Tammy Kiesh, to Tina Fontaine, to Amy Owen, to Courtney Scott, to Devin Freeman, to Chantel Fox, to Jolyn Winter, to Jenna Roundsky, to Zraya Akabi Kopet Kanens, and all the other children who've been broken in this system that failed them. Parliament needs to know that these children were loved, and we had an obligation to do better. And Mr. Speaker, the Parliament of Canada called on this government on December 11, 2019, just after we learned the horrific details of the death of Devin Freeman. They called on this Justice Minister to end his legal battle against the children. He has ignored the rule of Parliament. He's ignored the obligations under the order paper question. I ask you to address this, Mr. Speaker.
I will take this under the point of privilege under advice.